Hello, I'm Randy Kearns, and I want to briefly cover some of the topics or some of the highlights for the presentation for this week. The focus this week is healthcare data privacy. Since this really falls right in line with what we've already covered and specifically what we've talked about the last 2 weeks, it's actually a fairly short presentation, but one that I think again will continue the conversation as we talk about healthcare information security and data privacy. So let's see, let's get to our terms. Short list of terms this week, primarily because we don't have a lot of new information. And in fact, if you'll notice from the terms, a lot of this information we've already talked about before. HIPAA, by now, I hope you know and understand a lot of the details about HIPAA. Just understand HIPAA is really the cornerstone of privacy as we understand it today in the healthcare informatics world. PHI is either protected health information or personal health information. I've seen it written both ways. I'll accept both. Just understand it's private and it's personal and it's health information, particularly as it relates to you. HI is individually identifiable health information. I'll talk a little bit more about that when I get to the slide for IIHI. But again, the whole point there is at some point, if you're involved in research, we want to talk about what's identifiable and what's not identifiable. You would need that for something called an IRB, the Institutional Review Board. And so identifiable individual health information is something that we've got to guard against that being shared under most any circumstance with very few limitations. NPP, again, something we've talked about before, but it's your notice of privacy practice. Anytime you go to a doctor's office today or anytime you go to a hospital today, they will share with you their NPP. I'll also add that the notice of privacy practice, I think I've mentioned this before, but that has actually spilled over into the consumer world as well. And so today you're getting an NPP from Entergy or from Cox or whoever has your utilities, your credit card company, your bank company. And the whole point is to remind you that your personal information and you have a right to privacy to that information. That's yours, and you can decide how much of that can be shared. And if they're sharing any of that information, they have an obligation to tell you if they're sharing it and how they're sharing it. OCR is the Office of Civil Rights, and OCR again began during the George W. Bush administration, and then was significantly elevated and substantially funded as high-tech came about during the Obama administration. HHS is Health and Human Services. Again, HHS is that cornerstone agency that oversees really all of the healthcare services that are provided, at least on a national level. And that's the national coordinating organization for states that are either receiving funds or providing services, all related to healthcare. De-identified information, again, the whole point to that is if we're going to share information, particularly for the purpose of research, much of what you need should not be identifiable, meaning I should not be able to take that information and reconstruct it in a way that I can identify who the patient was that the information is tied to or linked to. And then the privacy officer is someone at each organization. It's usually somebody with another job in addition to this, although in some organizations, such as Ochsner or LCMC Health, where you have very large organizations, you have an individual who that is their sole job is to oversee the privacy component of of how information is shared or not shared, and to be sure that, again, from a protected health information standpoint, how that information is protected, and again, what is shared and what's not shared. The privacy officer also has an obligation to report HIPAA violations. If you suspect a HIPAA violation has occurred, the privacy officer is really the person that you would have to report that to, probably through your supervisor, but ultimately the privacy officer is responsible for coordinating that information. And then 10 common HIPAA violations. I have a couple of articles that I've linked to this week's presentation just to help you understand. And I've also added a couple more in the last several days, again, just to help us understand how HIPAA violations can be a substantial problem in a healthcare organization, and why we have an absolute obligation to guard against how that information could be shared or how it could get out. Again, the whole point to the law is to be sure that we understand both privacy and security. It is essential that HIPAA, again, came about in 1996. It was substantially revised in 2009. Other aspects of HIPAA, again, is protected health information, and then individually identifiable health information. And then examples of PHI, again, gets back to where are places where protected health information is located. And then in terms of what's protected by HIPAA, again, it could be your name, your social security number, driver's license number. Remember, MARCA, M-A-R-C-A came about, let me go back to here. Remember, MARCA came about to remove social security numbers from Medicare numbers. So all of the new Medicare cards today, let me go back to, all of the new Medicare cards today no longer include a social security number. And in fact, all of the Medicare cards were changed out for a unique number that was identified and put out by HHS. And then direct and indirect identifiers. These are, this is the list of 18 things that are considered direct and indirect identifiers. And then again, what's protected by HIPAA, and then again, the privacy officer is responsible for enforcing it. What else do I want to be sure and talk about? How can you use PHI and who may use PHI? Remember, HIPAA has requirements that only individuals involved in the continuous care of a patient or for billing purposes can that information be shared. Again, HIPAA has two components that allows information to be shared. That's people providing additional and involved in the care of the patient, and people involved in the billing of services. And then, and only then, can information be shared, and it can only be shared, there's limitations of how it can be shared. Let's see, what else do I want to be sure and talk about tonight? Again, you have to have someone's authorization to share PHI. Treatment, payment, and healthcare operations, TPO, is a good way to think about permitted uses. One other thing, this public policy exceptions does include public health and law enforcement, but again, only to the extent that's necessary. It is important for treatment, it's important for payment, it's important for healthcare operations, again, the TPO standard. And then how much is necessary to be shared? Again, the only thing that's necessary to be shared is what's required to perform a certain task. It's called the minimum necessary rule. What's the minimum amount of information that's necessary to be shared? And then safeguarding PHI, again, the onus is back on us to be sure that we're safeguarding that information. Certainly it's important not to discuss it in front of others. It's important not to leave your EHR open on a desktop or a laptop so that others may see it. It's certainly important not to access medical records that you have no business accessing. It's certainly important not to print information in public or unsecured areas. Also, if you have, if at some point in your life you wind up in administration and you have a laptop that's been assigned to you by the organization, or you have login capability to allow you to get into the EHR, it's essential that you guard that, almost guard that with your life, but you cannot allow that laptop to fall into the hands of someone else who may be able to access the database of your EHR. Again, that's a huge HIPAA violation. Occasionally, I've worked a lot in the emergency medical service world, and occasionally a paramedic would leave a laptop behind. Just understand that laptop can be networked with and can access many of the medical records of the patients that we've seen in the EMS world. And just as HIPAA has substantial implications for hospitals, it also does for any other healthcare organization, including EMS, home health, doctors' offices. Again, we all have an obligation to protect that health information, and there are substantial penalties and fines for people who are careless about that or don't do that in the manner in which it's intended. There's a couple of examples of how you safeguard PHI that's included in the presentation. I won't go over them tonight, but it is important that you know that. What else do we have here? Yeah, risky practices with computer use. Again, just being sure that you're not sharing information, you're not accessing information that you don't need, don't necessarily print or copy PHI. Again, the NPP, there's a couple of examples of NPPs I think that I've included. I've got more information in the presentation about notice of privacy practices, what your rights are. What else? Again, I don't want to necessarily continue to read this to you, but it is important for you to take just a moment to review what your rights are under notice of privacy practices. And certainly if you feel like they've been violated, how you can file a complaint related to that, what your choices are for who you can share the information with. There are places that the information can be shared that may include, such as a disaster relief situation. Yeah, we can't use your information for marketing purposes. We can't sell your information as far as a hospital goes. We can't use it for fundraising, but we can contact you for fundraising efforts, but you can tell us not to contact you again. Again, in terms of disclosures of use, how we have to use it, it's primarily in continuation of care, how we run our organization. Again, think back to the TPO, treatment, payment, and operations. Treatment, payment, and operations. Those are three key things to think about with how we can use protected health information. And there is a public health component. Again, if you wind up with a sexually transmitted disease, we at the hospital have an obligation to report that to a public health agency. And certainly they have an obligation to keep that private and confidential, but they will follow up with you if you have an STD, because they will also do contact tracing to try and identify sexual partners that you may have put at risk because of an STD that you have, or to try and identify who you may have contracted the STD from. Again, the whole point to public health is contact tracing and to try and identify who else is sick from what could be a communicable disease. In cases such as HIV, as an example, that's certainly a sexually transmitted disease. It's certainly paramount that from a public health standpoint, we try and identify who has potentially been exposed to someone with HIV, and then to, again, immediately screen them and begin treatment, and potentially put them on a regimen of medications to help them manage the condition. Same could be said for if you got some type of food poisoning, or if you were sick, and we can tie that back to a restaurant. Again, that's a public health notification, because they may need to notify other people who also visited the same restaurant, may have eaten some of the same food, may have gotten sick for the same reason. We typically think of that as hepatitis A more than anything else, but Hep A is somewhat common in the restaurant world if people aren't washing their hands. And although in today's world with COVID, the one advantage to COVID has probably caused us to do more to focus on our hygiene than at any point in the last 20 years. And so while COVID has nothing to do with hepatitis A, quite honestly, the challenges in the restaurant industry with hepatitis A is being sure your employees are always washing their hands thoroughly after going to the restroom. And if COVID doesn't do anything else, it should help us improve our personal hygiene to the extent that it also minimizes some of these other communicable diseases. We can use information for research, but typically it's de-identified, or if it's identifiable, there are certain security measures that have to be taken to be sure that the information is not shared inappropriately. I mentioned earlier, in terms of complying with the law, in most cases, privacy is guarded in a fairly substantial way. So if there is a court order that the information be shared, there are still limits to what can be shared. What can physicians disclose if they've been subpoenaed to appear before a court? Again, there are limitations to that. There can be, certainly if you're an organ donor, that information can be shared. Honestly, so I'm identified as an organ donor, and I would certainly want to be sure that information was shared. You know, if at some point I can't use them, I certainly hope someone else can. And so in terms of organ donation or tissue donation, those disclosures are permitted. In terms of working with a medical examiner or sharing health information, just understand we start to lose some of the privacy. Some of the privacy extends to the grave. Some of the privacy we lose because at a point that you die, cause of death, certainly for an investigation, can be shared as an example. There are disclosures related to workman's comp, law enforcement, and other government requests. But again, there is specific oversight that typically involves a judge before information can be disclosed, just simply because there are strict limitations to what can be disclosed. What else? What happens if we ignore the HIPAA requirements? So we don't want to ignore the HIPAA requirements, but let's talk about what some of those penalties are. In terms of disciplinary action, certainly you can lose your job. I've given several examples where people lost their jobs because they decided they wanted to look at something they had no business looking at. Civil penalties are substantial for an organization. If there's criminal intention in causing the harm, you can go to jail, you can be fined substantially, or both. Just understand, again, the privacy associated with HIPAA is substantial, and we have a substantial obligation in the healthcare world to keep it protected. And then you can also be held personally liable if there's an invasion of privacy or what's called wanton negligence, where you either did something foolish or you purposefully did something to share the information that was inappropriate. Again, criminal penalties, and then degree of severity. If you knowingly obtain information or disclose PHI, again, a $50,000 fine, up to 1 year in jail. Obviously, the penalties can be more harsh depending on how you intend to use the information that you criminally obtained. And it gets back to the Office of Civil Rights, OCR, that oversees this, and it is a federal crime, and so you would be prosecuted in a federal court, which really is a big deal. And so again, the best solution is to understand your obligations associated with HIPAA and be sure that you are compliant with your obligations associated with HIPAA. And these are the 4 tiers of HIPAA violation policies. And again, just some examples of what companies have settled in terms of HIPAA violations. $16 million settlement. At least 50 employees lost their job in the Jussie Smollett case. 10 most common HIPAA violations, discussing information, medical records being mishandled, lost or stolen devices, texting patient information, posting anything on social media. If you saw something at work, please don't put that on Facebook or Twitter or Instagram. You just have to be very careful about what you share about your professional life on what's considered personal platforms, and that is social media. Illegally accessing patient information. Again, the Jussie Smollett case was a good example of that, but there are plenty of examples of where people are just, they're curious and they want to know about what happened. And because they have access to the information, they decide they can look it up. And that's just not a good thing. You're working in the New Orleans area. For many of you who will be working in the New Orleans area, just understand there's a lot of celebrities that spend time here. And so there is some natural curiosity to want to know if Brad Pitt got hurt while renovating one of the homes that he had invested in as a part of the Hurricane Katrina reconstruction. And I'm using that as an example. If you decided you wanted to see what Brad Pitt's injuries were, you better be providing care for him or be involved in the billing process. If not, not only can you be fired, obviously you can be held with certain amounts of legal responsibility for what information you obtained illegally. And then again, social breaches, authorization requirements, accessing patient information on a home computer, and then lack of training. Again, the most common problems associated with HIPAA violations. And then the 10 largest, and these are older. Again, there's actually several examples now that are north of $10 million in terms of settlement fines. Yeah, and kind of the big picture here is it is safe to say that privacy is very important. It's really the cornerstone of what HIPAA was all about, and continues to be an important aspect of our obligation in the healthcare profession today. And with that, I don't think I have anything else I want to add. Again, the general conclusions: report unusual activity, particularly if you see questionable behavior, unauthorized use of your ID and password. Please do not share your ID or password with anyone. And if a patient or someone complains to you about a privacy issue, be sure that you report that to your supervisor immediately. And with that, let's kind of wrap it up and say, again, not a lot. Obviously, the presentation this week's pretty short. The topic is very important. I can't tell you enough the importance of privacy. I can't stress that enough. And I can't, I think next week or in the next 2 weeks, we'll talk about cybersecurity. Just understand technology today is both cure and curse. On one hand, it gives us fascinating amounts of information that allow us to make vastly better decisions than ever before, to do things in a timely way, to be sure that our patients are helped in a way unlike anything that we've ever really experienced before. And technology allows us to do that. Technology assures that, helps us be sure that we don't give the wrong drug, that we don't give the wrong amount of the drug, that we don't give the drug at the wrong time. There's so many really wonderful things that technology has done for us and helped us. I use the example of the hologram on Star Trek Voyager, which I don't know, was on TV probably 15 years ago. I really don't know how much, I don't know how far off we are from being able to see that, but I think in the next 5 years, you could realistically wind up talking to an artificially intelligent physician that is really a computer amalgamation for basic care scenarios. And technology has done that for us. Just the downside to technology is if someone accesses it for all the wrong reasons, they can have access to the universe of your history of any type of medical problems. For some people, that they don't have a substantial medical history. For others, it can be, and it can be particularly embarrassing under certain circumstances. And so I get back to, we have an absolute obligation to protect it, and we have an absolute obligation to use it the way it was intended to be used. But that certainly requires an important aspect of ethics. And that requires us to be sure that what we're doing is done with the right intention all the time. And with that, I don't have anything else for today. I hope by now you've recovered from the hurricane, you have electricity, you have a working internet, and I will see you next Wednesday here on Zoom. And meanwhile, if you have questions, as always, please feel free to give me a call or send me an email, and we can chat about it. Okay, let me stop here.